And just remind you, we are being recorded again. This is not an issue where we have necessarily victims or children or anything, but we always try to remind everybody, especially with our recordings, to not mention particular names in regard to victims or children. And also to keep your voice up, which I am very bad at not doing, so I'll try to remind myself as well, since we are being recorded in this day behind the podium. And also the monitor over there has the time, and obviously it'll be a little different for you guys because of the fact that you're dividing it up. And just remind me again, you want?
I'm going 6 and reserving 3.
Okay, 6 and 3.
Mr. Leister is going to go 4 and reserve 2.
Okay, thank you. You may proceed.
May it please the court. A cursory review of the trial court certification order conclusively establishes that a rigorous analysis of plaintiff's claims was obviously not conducted by the trial court. The order is 2 pages long. The order does not reference, much less analyze, any of the individual claims that are set forth in the plaintiff's complaint. It does not reference or refer to any of the actual requirements and elements of Civil Rule 23. It doesn't capture all of them. Instead, what the court did is it again attempted to redefine the class, and again ignoring this court's prior mandate. From our perspective for K&R, it is again inevitable that the certification order must be reversed for the reasons stated in our merit brief. And today I want to focus my argument time on our request for specific remand instructions. The basis for our request, for K&R's request of special instructions on remand, is that the proposed class, the class proposed by the plaintiffs in this case, has been fully adjudicated, and there's nothing left for the trial court to do other than determine and dispose of the named plaintiffs' individual claims related to their medical expenses. When the court rejected, this court rejected the trial court certification of the class proposed by the plaintiffs in Williams 1, the trial court then certified a different class for Williams 2, eliminating those individuals who had received a reduction on their medical bills and creating various subclasses. And the point we're trying to make here is that in certifying that class, the trial court necessarily rejected the class definition proposed by the plaintiffs. Plaintiffs did not appeal the trial court's rejection of that proposed definition in Williams 1. When this court reversed that certification in Williams 2, the trial court again redefined the class and certified yet another different class of individuals who had reduced bills, who had medical insurance, and who were told not to utilize their medical insurance. In certifying that class, the trial court again declined to certify the class that's been proposed by the plaintiffs. The point here is that the trial court and this court have both rejected certification of the class that was proposed by the plaintiffs.
Have we really? The Court of Appeals didn't take a position on whether the class should be certified.
Correct.
So it's hard to say we reject it.
Right, so in the end we have to have, this court needs the trial court to reject the certification. And our argument is that by not following your mandate, we have to assume that the court read and understood your instructions. If the court could have engaged in a rigorous analysis of the class proposed by the plaintiffs, it would have done so by creating different classes, sua sponte, by the way. These are not classes requested by the plaintiff. By sua sponte trying to create radically different classes, that is an implicit, it necessarily follows, it's implicit, but it necessarily follows, if the court understood your instructions, that it would not certify the plaintiff's proposed class. So all that's left to be done is to go back down, and there should be special instructions. And this is why I cited the Gene and Gene. We haven't seen this situation in Ohio, right? I could not find a case where a state court provided instructions like we are asking for. But we did find federal cases, and that's why I cited Gene and Gene, because that's exactly what the court determined in that case. There's nothing left for the trial court to do. It's the only thing left.
In that case, though, counsel, didn't the court previously determine on the merits the result of a rigorous analysis? in that fifth district? It's the fifth district case you're referring to? Federal Circuit, I mean?
Yeah, yes, it's Gene and Gene versus Biotech. I'm sorry, Nora, what was the question?
Well, in this case, Judge Carr's initial question was, has this court spoken to the merits of the argument of whether or not the class should be certified? In that case that you're referring to, when it gave the specific requirements, the court had previously, on a previous action, looked into the merits and made a decision on the merits. So is that case even persuasive to this case if the Court of Appeals doesn't believe that the merits have been spoken to?
It is, because in the first case, in that chain of cases, in the first case, the appellate court was careful to say that this does not mean that this class cannot be certified, et cetera, et cetera. Very similar to the instructions that this court has given. So I would, in my view, what this court needs, we would invite the court to reverse it on the merits. We've asked you to do that the last couple times and it hasn't happened. We ask again for that. But if the court is unwilling to do that because we can't find any precedent in state court, we only find it in federal court. If you have to have a reason that relies on the trial court's rulings, it has to be determined that the trial court has declined to certify the class proposed by the plaintiff. That class has been fully adjudicated. And I am reaching my 6 minutes, so I'm going to, unless there's a question before I sit down.
I don't believe so, thank you.
Okay, thank you.
Hello, my name is Daniel Leister. I'm here on behalf of Dr. Gubrial. I obviously echo the arguments raised by KNR's counsel, but I think it's important just to look at the actual Class A that was certified this time around. And I think it's pretty clear that there's really no level of rigorous analysis that the trial court could provide that would justify the class that they certified. I broke it down into what I see as 4 elements, numbered. The trial court didn't explain it that way, but I think it's easier to understand. The class consists of 1, individuals that did not receive a reduction in their medical bills from Dr. Gubrial. We can stop right there, because in the litigation, there's not a single class representative that did not have a reduction. Every class representative in this case had some type of reduction. So right off the bat, we have a problem just with the very first requirement.
Now, they contest that, though.
What do you mean?
Well, the other side says that's not true. They're saying there were people that, that did not receive reduction.
There could be people out there that did not receive a reduction. I'm talking about the class representatives in the case. So what we essentially have is a theoretical class where there may be some people that exist, but there's no one that's going to be presented in the case to represent that class. That's the whole nature of a class action.
Well, sure, but they can always substitute that.
That's true, but I mean, there's no evidence that they're going to find somebody or anyone's come forward that's had no reduction. So that's the first issue. Second thing is the individuals had to have health care, had to have health insurance, I'm sorry. I think that's easy to identify. The third thing is these individuals were told not to use their health insurance for the express reason to avoid any scrutiny from an insurance company. So that cannot be determined on any level without individualized inquiry. You can't know what any individual was told as to do you go through insurance or not, and the reason why they were told. So the third element of the class requires you to know what was every person told as to why not to use the insurance, and then the mens rea behind the person that told them that was to avoid scrutiny. So that's very individualized. There's no way to determine that on a class level. And then the number 4 is really the most glaring one, which is that the individuals would have fared better had they gone through their own insurance as opposed to without insurance. And that's the biggest issue here, and that's what we call the injury in fact. Because you can say there's overcharging, you can say there's all these issues, but at the end of the day, if an individual fared better than they would have had they gone through their medical insurance, they don't have an injury in fact. And this is important because Dr. Gubrial did not accept insurance. So if these individuals, we're comparing a situation where they treated with Dr. Gubriel to a situation where they would have treated with somebody else. Because had they gone through insurance, they would have been treating with a different physician, they would have potentially been getting different care, and we don't know what the reimbursements were, what the liens were, what any of the insurance provisions would have been. So it's impossible to compare from a class standard, how would these individuals have fared in the situation with Dr. Gubriel versus going through insurance and what would have been their ultimate recovery at the end. So I think on its face, it's just not a workable class, and I'll defer the rest of my time. Thank you.
Thank you.
Good morning. May it please the court. I'm Peter Patakos for the plaintiff class members who are the appellees and cross appellants here in this appeal. There's much to say in response to the arguments that were just discussed by appellants counsel here today. I will start by emphasizing what we agree with, which is certainly that a rigorous analysis was not conducted below, especially on this last order that is under appeal today. I would also agree with Mr. Popson that at this point special instructions would be appropriate. And I would say they would be especially appropriate in this case where we have the extraordinary posture of, and I believe this is on the record as well, which is where Judge Brogan has told us he is 85 going on 86 years old, and he is retiring from this case. Once this case comes back down to the trial court in whatever posture, whatever this court does, the first thing that's going to happen is that Judge Brogan is going to recuse himself and say he is retired. So we are going to get a brand new judge. I don't know if this will be a presiding judge of Summit County or if it will be yet another visiting retired judge. And I could go on about that, but for now I would like to emphasize three aspects of this appeal that I believe are especially salient for this court. The first is the limited scope of this court's, and the consistent nature of this court's two rulings in this case so far. We are now on our third appeal. The three of you were on the first panel, and two of the three of you, absent Judge Carr, were on the second appeal. You were consistent, and in fact, in your second opinion, you quoted the material part of that first ruling that still had not been addressed by the trial court, which were the three limited issues, which were how does the court certify the class? A rigorous analysis is required as to these three elements. The differing situations that the class members have regarding the insurance that they carry or otherwise don't carry. That's one. Number two, the so-called discounts, which to us are after the fact write-offs that some of the class members did get, or some of the putative class members, the roster of thousands of former K&R clients. That was number two. And number three, the question of whether disgorgement is an appropriate remedy, which certainly helps address those first two problems. So that rigorous analysis has never happened. So we would submit that. Of course we submit that it's important that this court get this case right. Of course it's important for this court to get all of its cases right, and we certainly understand that. But here what there is no dispute about, and has no court in this case, the trial court or this court, has ever ruled that the voluminous evidence that we worked so hard to get before the trial court on a very tight schedule back in May of 2019, that showed a pattern of conduct where specific rates for very specific categories of certain medical supplies and certain categories of medical treatment, which were mainly these injections, these trigger point injections, were uniformly charged pursuant to a uniform rate and process, far beyond rates that could be considered commercially reasonable, and charged, number three, charged in a way that was, as Judge Brogan wrote in his first opinion, apparently, quote, calculated to escape scrutiny by insurance carriers and other government agencies. Now, what I would like to emphasize on this appeal more than anything else, and we put it in both of our merit briefs, in particular, is the simplicity, both the simplicity of the calculations that are at issue here, that can be easily run, that fully address any issues with any differences in insurance, and any differences in so-called discounts that were offered after the fact. Both the simplicity of that calculation and the ease from which this information is derived from the record, from documents that Gubriel and KNR admit that they keep. And these calculations are set forth, and we did it for two of the clients, Thera Reed, who is a named plaintiff, and Shatari Beasley, who is another putative class member. She is not a named plaintiff. Maybe we would substitute her. These calculations are clear. They are set forth at pages 18, 19, 20, 21 of our appellee's brief. And they have never addressed these calculations. They have never come, either of the appellants have never come and said these calculations are faulty for some reason, that this information is not readily derived. That has never been addressed because we're correct about this, and we worked hard to get this info and to put this argument forward. And we submit that if there is any special instructions, it should be, gosh, this appears to be the rigorous analysis. We instruct the trial court that this appears appropriate, and that the case law, reams of case law from all over the country where courts hold that in these price gouging cases, you do not allow differences in individual treatment to defeat class certification in the face of evidence where there is a common scheme. We talk about the Restasis case, and we cite many other cases that are similar, where it reflects a common sense approach where the courts use average commercial rates. For instance, one of the former KNR lawyers said that 80% of the class members probably had Medicaid or Medicare. Those rates are known, they're published. We know what Medicare pays for trigger point injections. We know they don't pay anything for TENS units, etc. Office visits, Kenalog steroids that the clients were being injected with. And I think it's important to emphasize we are only talking about specific categories of treatment and supplies that these people were overcharged for. So Gubriel's counsel's argument about would they have been better off, that's just completely irrelevant. We're not looking at the overall settlement. We are looking at the specific charges for these particular items.
But Gubriel's argument relates to injury in fact, though, right?
Yes, it does. And what we have submitted, we've submitted it below, we've submitted it here, and again, we emphasize it in both briefs, where courts routinely, always, uniformly find that where there is a price gouging scheme that involves a group being subject to a price, being billed a certain price, they're incurring that legal obligation is the injury. That is the injury in fact. And how much it hurt them is exactly how much it hurt them. The courts recognize that they're in a worse bargaining position because they received the exorbitant rate. They're billed at the exorbitant rate. They were tricked into waiving their insurance and paying whatever Gubriel charged them out of their settlement. So that's the injury in fact. And
now, of course, they're disputing that. They're
Yes.
disputing, obviously, that there was any even legal obligation that arose.
And the difference is that they certainly represented to their clients that they had an obligation. The record shows that in every one of these cases, the clients received the settlement memorandum and said, you owe Dr. Gubriel this much. So, they can contest it, but the record is very clear. And another thing they don't have, Your Honor, is any case law that supports the approach that they're trying to tell you this is impossible, but courts do this all the time. Courts recognize the injury in fact from the illegal charge. And then the fact that you have a law firm dealing with its clients who, there's evidence in the record that the people that hire their lawyers based on TV ads, this is high volume, high advertising law firm. So you're talking about a population that is especially vulnerable. And this court wrote paragraphs, and this panel wrote paragraphs in the first opinion that it issued about Professor Nora Freeman Engstrom's affidavit that she executed for us that was attached to our class certification motion. She is the foremost expert in the nation on the manifestation of this type of high volume, high advertising law firm. And she traces back to 1977, the US Supreme Court's opinion in Bates that opened the door for attorney advertising. And what we're dealing with here is, that was 1977, holy cow, 55 years later, 58 years later, there were people hooting and hollering back then about that Bates decision. There were numerous amicus briefs submitted, and people were saying, there's a good reason why lawyers don't advertise and we don't allow this, et cetera, et cetera. Maybe those arguments didn't carry the day, and maybe that's for the best, but it certainly calls for lawyers, the profession, the courts, to recognize problematic manifestations, particularly when they rise to the level of fraud. And when you have evidence of a widespread fraud that is so clear that the only thing that the defendants can say is, well, we gave discounts after the fact to some of these people. I submit that this is exactly why that authority exists, that says when we have these situations, we use average rates, we can group the private insurance, the people that had private insurance, the people that had Medicaid, and the people that had no insurance, and we can have proceedings wherein the court can easily determine average commercially reasonable rates and determine damages that way. The court can even err on the side of the defendants in doing that. We would not object to that. That is simple, that is what happens in these cases, and we submit that that is what should happen here. And that if this court is going to give special instructions on remand, that would be very appropriate.
Let's say we don't go along with, or we don't even have to reach that issue as to when the injury in fact occurred, if there was any injury in fact, that it was not just the legal obligation. What these individuals' clients, their cases were settled based on the numbers of the medical treatment, the financial numbers for the medical treatment and so forth. So if you don't go by the argument that it is what they actually legally incur, not what they actually pay, then it would be a difficult, if not impossible, way of trying to determine how these clients were injured.
Well, that's why, again, I want to emphasize close attention to these calculations that are on page 19, starting at page 19 of our appellate brief. It's very simply, if you look at Thera Reed, who is a class representative, before I get into this, I don't want to forget, what Gubriel's counsel said is incorrect about how we would need a new class member, because two of the class members, Richard Harger and Monique Norris, the record reflects they did not receive discounts on their charges from Gubriel. All Norris got from him was the TENS units that he charged $300 a pop for, after paying $27 a pop for them, and just didn't tell anyone that he was going to charge them for any amount. So,
anyway, you have 2.5 minutes left, and I want to remind you, obviously, if you want to address your cross appeal.
oh, look, Your Honor, I believe that the appeal and the cross appeal are so related that I think these arguments apply to both. I would just like to emphasize with Thera Reed, so Gubriel purports that Thera received a discount of 13%, that amounted to 13% of her total amount billed. So in ultimately collecting $3,000 from Ms. Reed's settlement, that was 87% of the amount billed. So that adjustment can simply be deducted from the amount overcharged in an amount proportional to the reduction. So if Gubriel collected 87% of what he billed Reed, then 87% of the amount that he overbilled her using the commercial rates. Like we have submitted clear evidence showing that according to Medicaid's rates, Thera Reed was overbilled by $3,054.56. So if Gubriel gave her a 13% discount, then he gets 13% off of that overcharge. So in that respect, again, the focus is on the specific items that these clients were charged for. And they were overcharged for those specific items, which is why we focused on those specific items, because that is a simple analysis that is subject to class relief. Now, I guess in closing, I'll emphasize again the importance of the court getting this right, and including what we have submitted from the beginning is contained in Julie Gubriel's transcript. Evidence of kickbacks that Gubriel was paying, cash kickbacks that he would call olives from all these exorbitant charges. The record shows he collected $8 million just over the few years that are at issue here, 6 years or so. So one thing I want to emphasize is that these clients are only getting a fraction of what they lost, because we acknowledge from the start that we could only focus on these particular items of medical care. The trigger point injections, the TENS units, the office visits, the kennel log, the specific items listed. Sarah Reed needed surgery on her shoulder that she didn't get because she was put through this one-size-fits-all pipeline to get these, to be charged in this way, to be go to chiropractors and not receive medical care that she actually needed. She's injured for life because of that. She's never going to get that back. And there are certainly other class members like her, many others. So all we're here to ask for is at least what we can get, what the class action mechanism was designed to allow them to recover. So thank you.
And just for the record, 1977 is 48 years.
48 years.
Only because I graduated that year, and I'm like, don't make me any older than I am.
And I was born in 78, so I should have known. Thank you.
Rub it in. Okay, you do have your full 5 minutes. And you are going to use 3, right?
Right.
We only allow you to reserve 5 minutes. I know it says 5 minutes and 20 seconds. You have a couple extra seconds to sum up because he went a little over. Okay, thank you.
Very quickly, one thing I wanted to point out here is that in Williams 1, this argument about he can just have an injury in fact because of the charge itself. That's not the law of the case here. This court has already held, I'm reading from Williams 1, the Supreme Court has held that plaintiffs in class action suits must demonstrate that they can prove through common evidence that all class members were in fact injured by defendant's actions, citing Felix. Here, resolution of plaintiff's claims with respect to price gouging scheme will at minimum require determinations with respect to whether Gubriel's standardized rates constituted an overcharge, the extent to which Dr. Gubriel's clinic ultimately accepted reduced payments as satisfaction for each bill. So this court has already determined that those must be accounted for. He has already lost this argument in Williams 1, and he continues to make it.
Well, another reading of that would be that the court is saying these things need to be accounted for through a rigorous analysis, which was never conducted, obviously.
Right, what I'm saying is the court has said you have to account for the reduced payments. As far as we were concerned, that's been decided. He has to account for those. You've told him that you've told the trial court he needs to account for those. And when he realizes he can't, he just eliminates them. So he is rejected. He cannot conduct the analysis to get those people in this class. He's rejected the class twice, and there's nothing left to adjudicate. That's, where we brings me back to where I started. So there are certain items that this court has provided some guidance on that are more pointed than just, we'll just do an analysis. This court did give some guidance in Williams 1. Obviously in Williams 2, there was, it was a 2-page, 3-page order. There was not much guidance to give. Basically, see our prior order, right? And finally, I'd like to devote a little bit of my time to our arguments on the cross appeal. First of all, we argued waiver. Obviously, when the judge initially eliminated the plaintiffs who got reductions in Williams 1, plaintiff didn't cross appeal then. We argued that that operates as a waiver. I just argued the injury in fact for you, which is on the merits of that. And on the second assignment of error on the transcript, we again argued waiver because, in Williams 1, the plaintiff already knew that there was an order saying, I'm not going from the trial court, I'm not going to review this until after certification. He did not appeal it in Williams 1, did not appeal it in Williams 2, waived. To make it worse, not only did he waive it, he told the trial court, he agreed and told the trial court to go ahead and proceed without reviewing that transcript. It's in our brief, it's quoted directly from the papers filed by the plaintiff, that's invited here. You can't tell the trial court to do something and then later show the Court of Appeals and appeal because the trial court did exactly what you asked it to. And finally, I think the real tension here between the parties, or even the council, is the purpose of Rule 23. I think the plaintiffs have a distorted view of the purpose of the rule. It is not to punish defendants because you believe they engaged in actionable conduct. The purpose of the rule is for judicial economy, efficiency. The purpose is stated in the rule. The argument all along has been, these are really bad people, you should certify this class. It's an improper argument. We ask this court to remand this case to the trial court with special instructions that the case has been fully adjudicated. There's nothing left to do other than adjudicate the individual claims of those plaintiffs in Class A. Thank you.
Thank you.
Very briefly, I just wanted to touch base on something you said, Judge Carr. I think it is important to realize what your point as to the opposite side of the charge. So the way that this works is the client submits to opposing counsel or an insurance company or the tortfeasor what their medical bills are. The higher that number is, the higher the settlement will likely be. So Peter's clients, Mr. Patakos' clients, are getting a benefit on the settlement side. They're not accounting for any of that. They're saying there's injury, even if they got triple what they would have gotten had they gone through normal insurance, not through Dr. Grubrial, they're not accounting for any of the benefit side. They're only saying, well, we're going to take the extra settlement, but then we're going to argue on the opposite side that we were overcharged, we were overbilled, and then we want a discount on the back end. That's why this injury in fact element is so important.
So what are you saying then, that any fraud that exists is actually on either the insurance company that's settling or the defendant that's settling their cases?
It seems if there's anyone that's trying to be withheld from the scrutiny, it's the tortfeasor and the tortfeasor's insurance companies and the tortfeasor's companies. That's not a party in this case. If they had a qualm with it, they can bring a class action, but that's not what the situation is. And as to the claims that Dr. Grubrial mistreated any patients, I think that's wildly inappropriate. There's no medical malpractice claim in this case. It's not an appropriate argument. It's not relevant on this appeal. Thank you.
Thank you. Well, I have to say, I really appreciate all counsel's ability to stick to the time limits. I'm very impressed with that because usually we're trying to cut everybody off, and you all did a very nice job. Thank you for your presentations to the court. The court will confer on this and issue a written opinion that will be sent to all the parties, as well as we release it on an electronic version on the Supreme Court website. So if you're really, really anxious, you can keep watching that as well. So anyway, have a good day, and thank you